We're ready.
Call the Code Enforcement Board meeting of February 13th, 2014 to order. Would you like to do the invocation for us?
I'd be happy to do the invocation. Everybody can stand. You can. Our Heavenly Father, we seek blessings on the tasks before us. Bless our efforts with clear insight, our deliberations with wisdom, our work with clarity and accuracy, and our decisions with impartiality. We pray that our work this afternoon will find favor in your sight. This we pray. Amen.
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
May we have a roll call, please?
Yes, sir. Mr. Vesey?
Here.
I'm sorry, Mr. Sansoda is absent and excused. Ms. V. Casey?
Here.
Mr. Kramer?
Here.
Mrs. Archer?
Here.
Mr. DeMasas?
Here.
Mr. Slawinski?
Here.
Mr. Plunkett?
Here.
Please, your roll call.
Thank you. Our hearing procedures. The Code Enforcement Board hearing procedure. It is the intention of this board to promote, protect, and improve the health, safety, and welfare of the citizens of Tarpon Springs by providing an equitable, effective, and inexpensive method of enforcing various codes within the city of Tarpon Springs. Any aggrieved party may appeal a final administrative order of this board to the circuit court. Such appeal shall be filed within 30 days of the execution of the order to be appealed. Florida Statute 286.0105 requires any party appealing a decision of this board to have a record of the proceedings to support such an appeal. The procedure of this board follows with each case on its agenda is as follows. First, the city presents its witnesses and exhibits, after which the violator is able to ask the city's witnesses any specific questions regarding their testimony. Secondly, the violator is allowed to make a presentation and present any evidence or documents. Then the city can question the violator's witnesses. After both rounds of testimony, both on the part of the city and on part of the violator, each party is asked to give a closing statement, first by the city, then by the violator. After those three steps are taken, this board then closes the public hearing portion of the case to discuss it and take appropriate action. Before we begin the public hearings, we will have all potential witnesses stand up and be sworn in by the secretary of the board. Please turn off all cell phones.
Do you swear the testimony you're about to give the whole truth and nothing but the truth? I do.
That completes our swearing in. So we'll start with new business. Number 1 was deferred, 2 is complied, 3 is deferred, and brings us to case 13-800000970.
Good afternoon. My name is Cindy Sanner. I'm the Code Enforcement Inspector for the City of Tarpon Springs. There's no one in the audience for this case. This is case 13-800000970. The property address is 1021 Tradewinds Drive, and this is the estate of Joanne Skrupski. We received a complaint on October 28th of 2013. The caller stated that the trees and bushes were overgrown along the right-of-way, creating visibility problems for vehicles exiting Captain's Way and the complainant's driveway. I conducted a site visit on October 29th and confirmed the complaint. A lease pendants for foreclosure was filed on August 12th of 2013 by Nation Star Mortgage. This property was in violation of Codes 8-40, duty of maintenance of private property, 8-52, nuisance prohibitions, and 37.00, visibility triangle. The property owner of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, was sent a courtesy letter on October 29th, a notice of violation on November 19th, and a notice of hearing sent first-class mail and certified return receipt on December 10th. A site visit was conducted prior to each notification being sent. Copies of all documents were emailed or mailed. They were also mailed and emailed to Nation Star Mortgage. The property was posted on January 31st of 2014. I conducted a site visit yesterday, February 12th, 2014, and found no change. Photos were taken. This property is in violation of codes 8-40, 8-52, and 37.00. I recommend a compliance date of March 3rd of 2014 and a daily fine thereafter of $50 per day.
Are there any questions for the staff by the board members? I'd be happy to entertain a motion then.
I'll make a motion. I move based on the testimony, evidence, facts presented in the law that at the time of the alleged violation, sections 8-40, 8-52, and 37.0 of the code ordinances of the city of Tarpon Springs were enforced. The respondent has until March 3rd, 2014 to come into compliance with the code sections, or a fine of $50 per day shall be imposed for each day thereafter that the respondent remains in violation of said code sections.
Second.
Is there any discussion?
I just have one question. Are these trees considered overgrown?
Yes, things on the right-of-way are not to exceed 36 inches in height, especially within 30 feet of an intersection or 15 feet from a driveway. And those are all in excess of 36 inches tall.
Okay, because I think really, Cindy, I've seen an awful lot in this town that are a lot worse than this.
I'm sorry?
Excuse me, I'm sorry. I thought I'd seen a lot more in this town that are worse than this. But if they're not in compliance, then so be it. There you go.
Bobby, would you enter those into evidence, please?
Yes, sir.
Thank you. Any additional discussion? Well, let's have a vote then, please. Roll call, please.
Yes, sir. Mr. Plunkett,
Yes.
Mr. Swinsky,
Yes.
Mr. DeMassis,
Yes.
Mrs. Archer,
Yes.
Mr. Kramer,
Yes.
Ms. Casey,
Yes.
Mr. Vesey.
Yes.
The motion carries.
Item number 5. This is case 13-800000979. The property address is 520 Village Drive, and the property owners of record are Timothy J. and Beverly M. Golden. On October 31st of 2013, we received a complaint that there was an unregistered vehicle parked on the property and that the rear yard was overgrown. On November 1st, I confirmed the complaint. The side and rear yards were overgrown and the truck parked on the driveway had an expired tag. A lease pendants for foreclosure was filed on November 23rd, 2011 by SunTrust Mortgage. This property was in violation of codes 8-40, duty of maintenance of private property, 8-52, nuisance prohibitions, and 40.00, parking or storage of abandoned vehicles. The property owners of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, were sent a courtesy letter on November 4th, 2013, a notice of violation on November 21st, 2013, and a notice of hearing sent first-class mail and certified return receipt on December 9th of 2013. A site visit was conducted prior to each notification being sent. Copies of the documents were also mailed and emailed to SunTrust Mortgage. SunTrust responded by letting us know that they do not have legal possession of the property and are not able to correct the violations at this time. The property was posted on January 31st of 2014. I conducted a site visit yesterday, February 12th, and found no change. Photos were taken. This property is in violation of codes 8-40, 8-52, and 40.00. I recommend a compliance date of March 3rd, 2014, and a daily fine thereafter of $25 per day.
Any questions for the city staff?
Yeah, this is still under the ownership of the residents, not
Yes.
the bank yet?
Correct.
Under the resident, okay.
Correct.
That looks like a pretty new vehicle.
I have no idea what year it is.
One thing to leave your house, but you have a nice car sitting out in the front yard.
I have a question.
Sure.
The case that was just previous, we had a daily fine of $50. This one is $25.
Because the visibility triangle is a safety issue. This is not.
And-
The
and that
front
ties
yard is
back
being
into-
mowed, the truck is backed in to the driveway, and the overgrowth is in the rear yard. So this is, in my opinion, a lesser violation.
When does it become the bank's
When it,
responsibility?
I think Attorney Trask can probably let you know what the process is.
When the lis pendens is originally recorded, that's like the first day that the case is filed. That's just a notice that tells the public that there is this case pending. So if you were to look in the public records, you would see it. The bank is
Excuse me, case meaning
foreclosure case. The
Okay.
bank is foreclosing on the property. The bank will take ownership of the property if they buy it at the judicial sale, once it's sold, to pay for whatever debt is here. Often they are the purchaser at the judicial sale. There are some times when third-party purchasers come in and purchase it instead of the bank. Depends on how much the bank is willing to bid at the sale. So even though there is a foreclosure case pending here, they have not completed it yet, otherwise it would have come up in their search. And when they do the tax record search, it would show that the bank would own the property. In this particular case, the tax collector is saying that the borrowers are still in possession and still own the property. So that
How do you
process
stop
could
that?
take a number of years depending upon how fast the bank pushes it.
And currently, it's taking over 800 days and up to 5 years
And then they
for
come
banks
back.
to take possession.
If they end up with it, they come back and tell us to cancel out the, all right. And that sucks.
I'd like to make a motion.
Do we have any other questions for the city? And then, yes, we could have a motion.
I move based on the testimony, evidence, facts, and presented at law that at the time of the alleged violation, Section 8-40, 8-52, and 40-00 of the Code of Ordinances of the City of Tarpon Spring was enforced. The respondent has until the March 3rd day of March 2014 to come into compliance with the code section, or a fine of $50 per day shall be imposed for each day thereafter that respondent remains in violation of said code section.
Do we have a second?
Second.
Is there any discussion?
Well, the only reason I said 50 was what you said, Mr. Chairman, was basically the last one we did was 50. And even though there's a triangle issue in the last one, this one looks, no triangle maybe, but still all three are the same violations, 8, 40, 852, and 40. They're all the same, so.
And I beg to defer. 40, this case is 40.00. And the other one was 37.00.
I
There's a
can't hear you,
difference.
Cindy, I'm sorry.
Really, this is supposed to be discussion up here, Cindy, so the other board members could pipe in if they want to,
Okay.
but
Have we checked those photos into evidence yet? Could we check those photos into evidence now?
I've got them right now.
Any more discussion?
Thank you.
Roll call, please.
Mr. Plunkett,
Yes.
Mr. Solinsky,
Yes.
Mr. Massas,
Yes.
Mrs. Archer,
Yes.
Mr. Kramer,
Yes.
Ms. Vaquesi?
Yes.
Mr. Vesey?
Yes.
Your motion carries.
This is item number 6, case 13-800000984. The property address is 107 East Park Street. It is a vacant lot, and the property owner of record is Limnos Construction and Investment Incorporated. We received a complaint on October 31st, 2013, that there were boats and other items from the Limnos property across the street being relocated to this vacant lot. I conducted a site visit on November 1st and confirmed the complaint. There was a car, a boat, a van, a topper, and miscellaneous other items being stored on this vacant lot. This property was in violation of codes 57.00 outdoor storage and Appendix B smart code adopted. The property owners of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, were sent a courtesy letter on November 5th, 2013, a notice of violation on November 21st of 2013, and a notice of hearing sent first-class mail and certified return receipt on December 9th, 2013. A site visit was conducted prior to each notification being sent. All of the items except for the boat were removed from the property by November 21st of 2013. The boat is owned by Teddy Georgiou. We've been in regular communication with him. Since he did not have title to the boat, the Coast Guard had to be contacted to make sure it was not stolen. He finally did receive title to the boat on January 28th of 2014. In order to safely remove the boat, some repairs have to be made to it, and he's been unable to make those repairs due to his health. He has assured me that the boat will be removed within the next 30 days. I posted the property on January 31st of 2014, conducted a site visit yesterday, February 12th, and found no change. Photos were taken. This property is in violation of codes 57.00 and Appendix B. I recommend a compliance date of March 15th of 2014 and a daily fine thereafter of $25 per day.
Any questions of the city staff?
Yes, I have a question. Were the pictures we saw today taken yesterday?
Yes.
Okay. My question is, to me, there's only a boat left there now, correct?
Right.
So they did move the other boats and a car?
Correct.
Okay, and van topper?
Yes.
And all that other. So
Yes.
the only thing he is in violation of now is that boat that is still sitting, all the
Correct.
other things have been taken care of?
Correct.
Okay, thank you.
You're welcome.
Limnos Construction owns the property. Did they put that big boat there?
I'm assuming that they did. They own the property across the street, and that property was in fine status, and the bank took it over, and it was either the property owner or the bank that put it on that piece of property.
Because I'm curious, there's a third party involved here, the owner of the owner of the boat, and if he's not moving it, and Limnos is gonna be in trouble because he won't move it, unless they put the boat there.
I think at one time, Teddy was part owner of Limnos. He is not anymore,
Okay.
but he is the owner of the boat.
Okay, thanks.
Bobby, would you check those photos in as evidence, please?
Yes, sir.
Any other questions for the city? Would someone like to make a motion?
I'll make a motion. I move based on the testimony, evidence, facts presented in law that at the time of the alleged violations, Section Section 57 and Appendix B, Smart Code adopted, of the Code of Ordinances of the City of Tarpon Springs were enforced. The respondent has until March 15, 2014, to come into compliance with the code sections, or a fine of $25 per day shall be imposed for each day thereafter the respondent remains in violation of the said code sections.
Second.
Any board discussion? Roll call, please.
Mr. Plunkett?
Yes.
Mr. Swalinski?
Yes?
Mr. Demosas?
Yes.
Mrs. Archer?
Yes.
Mr. Kramer?
Yes.
Ms. Casey?
Yes.
Mr. Bessie?
Yes.
The motion carries.
This is item number 7, case 13-800010000. The property address is 14 Mill Street. The property owner of record is Vicky Pastrikas. We received a complaint on November 12th of 2013 via an email from Pinellas County Animal Services. They received an email complaint that there were chickens on this property that were not being given clean water. On November 12th of 2013, I called the property owner and left her a voice message that we received a complaint that she has chickens on her property that are not being properly cared for. She also did not have a permit from the city to have the chickens. On November 13th, I called the property owner and she acknowledged having chickens. I told her she either needed to obtain a permit to have the chickens or she would have to remove them from the property. And during one of my site visits, I also heard a rooster. They are totally prohibited by code. This property was in violation of Code 4-3, Animals on Residential Properties. The property owner of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, was sent a notice of violation on November 13th of 2013 and a notice of hearing sent first-class mail and certified return receipt on January 7th of 2014. A site visit was conducted prior to each notification being sent. On December 16th of 2013, I again discussed the case with the property owner and let her know what needed to be done to come into compliance. The property was posted on January 31st of 2014. On February 11th of 2014, I again discussed the case with the property owner. She stated that she would either get rid of the chickens or get the permit within the next 2 weeks. She was unable to attend today's hearing because she has 2 small children. I conducted a site visit yesterday, February 12th, and found no change. I could not access the property to take any photos. This property is in violation of Code 4-3. I recommend a compliance date of March 3rd of 2014 and a daily fine thereafter of $50 per day.
Any questions for the city staff?
How long does it take to get a permit? I mean, she can get a permit, right?
I honestly don't know, maybe, a day, couple of days.
I have a question. The photos were of an overgrown vacant lot. Must
This
be
is
hard
the
to
ne-
look at
this
the
is the
picture.
next case.
I'm sorry, those are the wrong, those are the
okay.
wrong
This is the next
photos.
case.
we can't see any chickens.
I apologize, the 2 cases got stuck together, and
Okay.
I apologize for that. Those are not the
So there are no
photos.
photos?
Those photos are for the next case.
Okay,
Sorry.
all right.
We're right
Okay, so I'll just clarify
My
is
error.
that the
Yes.
chickens are at a residence.
Yes.
Okay, and they're in a coop.
She says that they're in a cage, and there's, not only does she need a permit, she needs to comply with the conditions in the permit, which specifies how the animals or how the chickens can be kept in her backyard. There's setback requirements and coop requirements and whatnot, so she needs to comply with that.
And you saw the chickens?
No, I heard them.
You heard the chickens?
Yes,
And a
her
rooster?
backyard is totally enclosed with a wooden stockade fence.
Okay.
But she admitted to you that she had chickens.
Yes, and I heard the rooster when I was there. There is also an active case for this property. She installed a shed and a fence without permits, and she has yet to comply with that ruling.
Any other questions for the city?
It doesn't pertain to this. Never mind.
Well, we don't have any photos to check in evidence. And do we need to pass those other photos back?
Not unless anybody needs to see them again. If Bobby can just hold on to them for the
Okay.
next case.
Then we'll take
I'll make
a
a
motion if someone would like to.
I move based on the testimony, evidence, facts presented at law, that at the time of the alleged violation, Section 4-3 of the Code of Ordinance of the City of Tarpon Springs was in force. The respondent has until the 3rd day of March 2014 to come into compliance with the code section, or a fine of $50 per day shall be imposed for each day thereafter that the respondent remains in violation of said code section.
A second.
It's gonna be some expensive chickens.
Any board discussion?
That's a poultry
A
salt.
roll call, please.
How much was the fine?
$50.
Okay.
Expensive
Buy a lot of
chickens.
eggs for that.
Yeah, you're right.
Mr. Plunkett,
Yes.
Mr. Slabinski,
Yes.
Mr. Demosas,
Yes.
Mrs. Archer,
Yes.
Mr. Kramer,
Yes.
Ms. Vacacy,
Yes.
Mr. Bessie.
Yes.
Thank you. Please roll call.
Can I ask just one last question? Could you still hear the rooster last time you were out there?
Yeah.
Wow, I'd be mad if I were a neighbor. Those things start real early.
This is item number 8, case 13-800010009. It's a vacant lot next to 524 East Lime Street, and it has a parcel ID of 132715-46638-003-0060. It is owned by GGH21 LLC. We received a complaint on November 12th of 2013 that this property was overgrown and not being maintained, and those are the photos that you already reviewed, and there's no one in the audience for this case. I conducted a site visit on November 15th and confirmed the complaint. The vacant lot was overgrown, had trash and debris and yard waste throughout. This property was in violation of codes 8-22, accumulation of trash and debris on private property, 8-40, duty of maintenance of private property, 8-52, nuisance prohibitions, and 133.02, tree maintenance. The property owners of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, were sent a courtesy letter on November 18th of 2013, a notice of violation on December 6th, 2013, and a notice of hearing sent first-class mail and certified return receipt on January 2nd of 2014. A site visit was conducted prior to each notification being sent. The property was posted on January 31st of 2014, and I conducted a site visit yesterday, February 12th, and found no change. Photos were taken. This property is in violation of codes 8-20, 8-40, 8-52, and 133.02. I'm recommending a compliance date of March 3rd, 2014, and a daily fine thereafter of $50 per day.
Any questions of the city?
Yeah. Where does the owner live?
It's, hang on. Aventura, Florida.
So he doesn't have to look at it, so
No.
it's not a big deal for him. Okay.
Where do they live?
Not in Tarpon. Out of sight, out of mind. I'd like to see a higher fine.
Where did you say they live, Cindy?
Aventura, Florida.
Aventura?
I'm not too sure where
Aventura.
Aventura is.
Never heard of it. Okay, thank you. Wherever that is.
Any other questions of city? I'd be happy to take a motion.
I'd like to do it.
All right.
I move based on the testimony, evidence, facts presented in law, that at the time of the alleged violations, sections 8-22, 8-40, 8-52, and 133.02 of the Code of Ordinances of the City of Tarpon Springs were in force. The respondent has until the third day of March 2014 to come into compliance with the code sections, or a fine of $100 per day shall be imposed for each day. Thereafter, the respondent remains in violation of said code sections.
I'll second that.
Me too.
We got a 1.5 and a 1.5.
Is there any board discussion?
I just want to say that the reason I do that is I get really irritated with people that don't live in the city and they pay no attention to their property, and the other people that live by it have to put up with it. And I just think maybe it'll get his attention. He's ignoring Cindy.
Bobby, would you check those photos in the evidence, please?
Yes,
And I believe we're ready for a roll call.
okay. Mr. Plunkett,
Yes.
Mr. Slabinski,
Yes.
Mr. Demosas,
Yes.
Mrs. Archer,
Yes.
Mr. Kramer,
Yes.
Ms. Vacacy,
Yes.
Mr. Bessie.
Yes.
This is item number 9. This is case 13-8000, excuse me, 1068. The property address is 701 Bayou Avenue, and the property owners are George and Mary Patakis. We received a complaint on December 30th, 2013, that this lawn was overgrown and there was a large pile of tree debris on the property. I conducted a site visit on that same day and confirmed the complaint. This property was in violation of codes 8-22, accumulation of trash and debris on private property, 8-40, duty of maintenance of private property, and 8-52, nuisance prohibitions. The property owners of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, were sent a notice of violation on December 31st of 2013, and a notice of hearing sent first-class mail and certified return receipt on January 17th, 2014. A site visit was conducted prior to each notification being sent. The property was posted on January 31st of 2014. I conducted a site visit yesterday, February 12th, and found no change. Photos were taken. Since 2007, I have opened 10 cases on this property for failure to maintain the property. He doesn't do it unless he gets a letter. So this property is in violation of codes 8-22, 8-40, and 8-52. I'm recommending a compliance date of March 3rd, 2014, and a minimum daily fine thereafter of $50 per day.
But this isn't a repeat?
No, he's always, after being sent either a courtesy letter, notice of violation, he's come into compliance, and
this is
this time
10
he has
times?
not, so
Wow.
he didn't this time.
10 times.
Do they live there now, or
No.
is this a rental property?
This is a rental, this is a rental property.
Are there any questions for the city? Would someone like to make a motion?
I'll make a motion.
Okay.
I move, based on the testimony, evidence, facts presented in law, that at the time of the alleged violation, Section 8-22, 8-40, and 8-52 were in force in the city of Tarpon Springs. The respondent has until the third day of March, or a fine of $100 per day shall be imposed for each day thereafter that respondent remains in violation of said code section.
Second.
Any board discussion? Would we check those photos into evidence when you get them? And
Yes, sir.
a roll call, please.
Okay. Mr. Plunkett,
Yes.
Mr. Slavinsky,
Yes.
Mr. Demasis,
Yes.
Mrs. Archer,
Yes.
Mr. Kramer,
Yes.
Ms. Casey,
Yes.
and Mr. Vesey.
Yes.
Cindy, was that house vacant?
It's a duplex rental. One of the units is vacant, the other one is being rented out.
So the owner doesn't live on site?
He lives out of state. He lives in New Jersey.
Got him too.
There are no affidavits of noncompliance. Would someone volunteer to make the affidavits of compliance?
No, he's not here. I move we accept the affidavits of compliance on the following cases. Case number 0300000879. Case 10-20000092. Case number 13-80000241. Case number 13-80000676. Case number 13-80000709. Case number 13-80000858. That is it.
Second.
All in favor, say aye.
Yep.
Aye.
Aye.
Any opposed? Motion carries. So for old business, we have a request for reduction in fine. Is there anyone in the audience for this request?
be.
I don't know, I gotta read this letter again.
Okay,
I read it already one time, Wanda, and I don't like people when it's a real estate agent asking for it.
Well, this is what we saw on the internet, on the,
Robert Shop.
Well, you want me to talk about those? Here, this is, as you know, a petition for reduction of fine, so you're supposed to make your determination based solely upon the written petition that you have in front of you. It looks like you have the request itself, you have an affidavit of compliance, and you have the city's response to that. It's in the package, too.
I'd like to know what the fine is for this one.
$49,960.
Wow,
49960.
49,000?
Oh, and my recollection was to go down to 10%.
This is the Christine Potvin. Cindy, have you had any trouble with this particular? Oh, okay, let me ask this gentleman.
Mr. Sherman is here. He's the one that would be able to answer any questions you have. Were you sworn in, Gary?
Swear 'em in first.
Okay. Bob, you
Are
want
these gentlemen going to speak too? Should we swear
No,
them
they're
in?
here for the petition for, they probably won't, so.
Do you swear to testimony you're about to give us the whole truth and nothing but the truth?
I do.
Thank you.
On this reduction in fine for 102 South Camellia Avenue, 49,000 means that they haven't been listening to us for quite some time.
I can
'Cause
tell you a
You
little.
don't get 49,000, in a month.
It's actually about 43 months that it's gone on.
43
I can-
months?
Yeah, I can tell you a little bit of history on this.
Hold on a
guess.
second, Gary. The way that works is he has to ask you specific questions.
Okay, I'm sorry.
No narrative. You have a question, Mr. Plunkett?
Yes, well, that was one question I had. Have you had any problems with this particular piece of property from either the owner or anybody associated with the property?
No,
You have had no problem?
no.
Isn't it my recollection that the bank is asking for this because now it's in the bank's hand?
I guess this would be a board discussion question.
Yeah.
I don't have the answer to that.
Okay, the letter that you just let me see, wasn't that from
It was from a realtor.
okay, whoever's,
I guess,
So
with-
it's-
amongst ourselves, I guess I find it curious why a realtor who's not the owner of the property
Yeah.
is writing a letter making a request for reduction in fine, because Christine Potvin of Keller Williams Realtor Account Manager is
Right.
not the owner of the property.
And it looks like Robert D. and Sherry Shop are from Wickiwachi, but they may own the property at Camellia Avenue. Is that not correct?
I'm not familiar with who owns it currently, other than probably what you're looking at. I know that the bank did own it.
Well, it says here the current property owner is
Mortgage company.
U.S. Federal National Mortgage Association, property appraiser and tax collector, and they've got all that. But you must be Gary Sherman, is that
I
correct?
am, yes.
You find that it is in compliance now?
That's
But that
correct.
was since '09.
That's correct.
Well, I don't necessarily mean it's 5 years, because this is 2014, but it's got to be at least 4 years.
I had counted it out as 43 months, so whatever that comes to.
I have a question, Gary, just a clarification. Is this a property where a sewer main was extended into an area that did not have sewer connection, and then everyone in that area was required to make a connection?
That's correct.
And this particular homeowner chose not ever to make that connection?
That's correct.
But now it's under different ownership, correct?
Yes, it is.
So if we're asking for a reduction of fine, is that a reduction of fine going to the old owner or to the new owner who complied with the requirements and hooked the house up to city sewer?
I'll answer that question. It's
All right,
a
sir.
legal question. If you're going to reduce the fine, it's going to be on the original order that was entered. It would be against the original property owner. That releasing that fine or a partial part of that fine would ultimately release the obligation from the property that the bank now owns. So they will get the effect of it, but it will basically be releasing the original lien or a partial portion of that lien. So both people get the benefit of it if you reduce it, is the bottom line.
I have a question for Mr.
I'd be glad to make a motion on
Would it
this
be
one.
normal for
You
a
ready?
realtor to act as agent for the bank in a request for fine reduction?
We've had them before. I'm not really sure what the connection is here.
Well, she indicates she's managing the property for Fannie Mae.
So she is the bank's representative then, is what she's doing, the current owner's representative. But she's not a lawyer.
Are there any additional questions for the city staff?
No, but I'll be glad to make a motion.
I would be happy to hear a motion. Go ahead.
I move that the fine of $49,000 in the case of citation number, just flip the page, 10-200000092 of the Code of Ordinances of the City of Tarpon Springs, oh, I'm sorry, reading the wrong one, be reduced to $10,000. This reduction will occur upon payment of the stated reduced amount if paid within 60 working days of this order. Failure to pay the reduced fine will result in the original amount of $49,000.
I'll second that.
Any board discussion?
I'd like to just bring up the point that the city itself has indicated that they recommended reducing the fine to 10% of the accumulated fines, which would bring it to 49.
Where do you see that,
60.
sir? I don't see that.
Sir, that's in the January
But you did what you wanted to do.
7th, 2014 letter from the city, city's response to reduction of fines request.
Okay. Well, I'm going to still let mine stay.
That's fine.
Okay.
It's been seconded, so.
So we have a second. We had some good discussion, and roll call, please.
Mr. Plunkett?
Yes.
Mr. Swansky?
No.
Mr. DeMasis?
No.
Mrs. Archer?
No.
Mr. Kramer?
Yes.
Ms. Casey?
Yes.
Mr. Vesey?
No.
It failed, it's 4-3.
So the motion failed? Would we discuss again or take a second motion?
Another motion if you wanted to.
Would
Either-
someone like to make another motion?
Might as well amend your motion, make it 5, make them happy.
No, I won't.
Okay.
Yes. Would that be here?
I can appreciate your concern.
Yeah, you just make a regular motion.
Don't I have to read it? Yes. I'd like to make a motion that we go along with the city of Tarpon Springs and reduce the fine to 10% of the total accumulation of fines, which would bring the fine to $4,996.
For Christ's sake.
$4,960.
Do we have a second?
Second.
Any board discussion? Roll call, please.
Yes, sir. Mr. Plunkett?
No.
Mr. Swansky?
Yes.
Mr. DeMasis?
Yes.
Mrs. Archer?
Yes.
Mr. Kramer?
No.
Ms. Casey?
No.
Mr. Vesey?
Yes.
Motion carries.
I'm not gonna get paid anyway, so it doesn't matter.
So, item number 17, continuing old business, request for reduction in fine, case number 11-2000010 at 160 Reed Street.
All right, let me tell you what this is all about, and you've got Mr. Beckel and his son in the audience today. This is agenda item number 7. They're asking that you set aside the affidavit of noncompliance that you have already accepted at the last meeting and grant a new compliance date. In other words, move the compliance date out farther to allow them to complete their project without the fine running. So that's the request that's in front of you. You see that there is a lengthy letter and some backup and a chronology of events, milestones, and so forth that the Beckles have included for you to take a look at, as well as a letter from their structural engineer requesting that you give additional time to bring the property into compliance, considering the size of the project.
Get your thing online, or do you?
So the way this would work then is as if you were going to consider it, that you would just make a motion to set aside the acceptance of the affidavit of noncompliance,
You go online to get it.
and then you would set a compliance date somewhere down the road.
Mr. Trask, is there a suggested compliance date on the road?
Didn't we give them an extension in the beginning?
I don't know the answer to that question.
I think we did.
Anthony is here from the building department. I think this is his file. He may be able to answer that question for you.
Anthony, were you sworn in?
He was sworn in.
He was sworn in.
Yes.
You know, may I just say something here? I get my stuff online instead of a packet delivered to my house, and I didn't see any of this stuff. So, it'd be nice if we get it online, if we get everything, or else get it at least where I can read it at the meeting before we start the meeting.
Are there any questions for city staff at this time?
There was a question pending from
yep,
Anthony
sorry.
whether or not that there had been a previous extension of time.
Wasn't there a previous extension to this?
No, sir.
No?
No, sir.
This is the one on Reed Street?
Yes, sir.
Have they made a lot of improvements?
There were tons of improvements.
Yeah.
I remember voting on this.
Yep.
Might have been back in 11. Yeah, it might have been back in 2011 when I was on the board at that time.
I have a
That's
question.
when it first appeared.
What's that?
I have a
That's when we
question.
first got it.
You
Do you
remember,
reasonably
Wanda?
concur with Mr. Trask's interpretation of the request and
Back in
of
November.
what he suggested there?
I
that
don't care what they've been
An
doing. I'm
extension
telling you
of-
what we did.
We should give them a reprieve.
It's basically to
Well, I think
vacate the
property's
affidavit of
great property,
noncompliance,
Great piece of property.
the
but
acceptance of the affidavit of noncompliance, and give an extension or a longer compliance date. I guess that's a question to you, Anthony. Do you see that there needs to be more time given to get this project done?
I know there was a lot of work to be done. Okay? Certainly
It's
can't
an
find-
extensive project.
Are the people here?
Yeah.
Well, if they've been working on it and making progress, I recall, it sounded to me like it was gonna be a really neat thing, but it looked like it was gonna be a lot of work. Would it do any harm to give them more time to do it, since, if they weren't doing anything, I could understand denying this, but if they are working on it, I can understand how they can run up against delays and setbacks.
Well, they're here. If you have questions for either Mr. Beckel or his son, we can swear them in, and you can ask them questions, and they can tell you what they're doing or what they have done, and maybe help you answer some of those questions, if that's what
Yeah, I
you
don't-
want.
Appreciate that.
I don't want to be a hard ass on this, but I would like to talk to them about it.
Could I ask a question of the city's representative?
Absolutely, please, thank you.
Okay. Again, I don't know that I heard your response, but in your opinion, as a professional, have you seen progress, or is it completely stalled from what you've been able to determine?
In reference to the site itself, there was 2 cases. One in the rodents, that's been taken care of, so they did take care of that. The initial case of all the violations that exist today are still in existence as of today.
So you haven't seen any progress since the previous case involving this particular location?
In reference to the structure, no, sir.
Okay.
There was a request for the Beckles to come down here, and one of the board members had questions.
Gentlemen, will you raise your right hand for me?
seen one now.
Do you swear the testimony you're about to give us the whole truth, nothing but the truth?
I do.
Thank you.
Board, I'd like to make sure we've asked all the questions of the city before we address our guests.
Fine.
And I have a question of the city. Is there a written city response to the request for reduction in fine?
It's not a reduction of fine.
Excuse me,
To change the compliance date.
change the compliance date?
No, sir.
Do you have an opinion? I'm just trying to get the feeling here, if they're not doing anything, then I can understand the city saying, no, we've got to, finish this. But do you feel like they are progressing?
Indication from the owners indicated that they are progressing, but I have not seen nothing in our office as far as permit.
Now, are they supposed to report to you when they get certain things, certain items completed?
They actually would need a permit for this structure.
They haven't gotten a permit?
No, sir.
Not that you're aware of, you said?
No, as of today, no, sir.
How can they get all that stuff done without a permit?
Okay, that's going to be my question. Excuse me, on the page 3 of the packet,
Yeah,
I mean, there must be probably close to 2 dozen items that are listed, and they're all complete with prices. I mean, the first thing that popped in mind, they had asbestos survey completed. They didn't need a permit to have them come in for asbestos and possible remediation of asbestos?
No, sir. That's a requirement by the city and also by Pinellas County. Prior to permit submittal, I need an asbestos survey done from the occupant.
So that has to be done. Then they submitted paperwork to go ahead and get a permit to have that taken out.
Yes, sir.
Okay.
but most of the completed things here are entering into a contract.
Well, they're engineering.
That doesn't mean that the work has been done. It's just a contract that's been signed.
That is correct. Does anyone have any more questions for the city staff? Okay. Then we'll be able to ask questions of our violator.
Just need to get name and addresses first, and
May I have your name and address, please?
Andrew Beckel, 123 Reed Street, Tarpon Springs, Florida, 34689.
Richard Beckel, 123 Reed Street, Tarpon Springs, 34689.
Thank you for coming today.
Thank you.
Now, did we not hear from both of you gentlemen one time, or maybe at least one of you, back in 2011 about this property being refurbished, redone, and reconstructed?
Yes, we've been here several times.
That's what I thought. What was the date? I don't know what the date of completion was, the original date.
Completion
Of 160 Reed Street.
right. Well, the reason there wasn't a whole lot done for the codes is because we're planning on demolition, except for the facade and the tower of the building. So there isn't a whole lot of sense in putting money into a building that's going to be torn down.
I don't think they can hear you. Can you get that
I'm sorry.
microphone closer?
Let me
please?
answer the question. This is a partial demolition with the facade and the bell tower being preserved in the new building. And so therefore, it would be unwise and uneconomical to comply with the current violations, seeing as it's mostly a tear-down situation.
When did you plan on demolishing this?
It was as soon as we were permitted. However, we have not been able to get a permit because of the fact that we have to do all the design and the structural engineering as well.
That wasn't part of the agreement that we had that when you first came here in 2011?
It was, however, we lost our contractor, left the country after a year into the project.
I hope you didn't pay him.
No, we did not, unfortunately.
Uh,
So we kind of changed horses midstream, which wasn't an ideal situation.
What are we looking at this particular point? You're saying you want an extended date. What are we looking at?
We would be in compliance once we have a CA from the city, is my understanding. And that's
A CA compliance of,
a certificate of approval for construction.
and what do you need to do for that, according to
We
the
need to
city?
have our new contractor submit these plans that are completed and sealed.
Have they been submitted?
No. We just got these last week.
Do any of the board members have questions?
I have a quick one.
Yes.
Mr.
Yes, Richard?
Did you give your address as this place?
No.
No, 160.
Our residence is on the same street.
Oh, okay.
Two
I
houses
just heard
away.
Reed Street, and I
Right.
thought, are you living
Right.
there? Okay.
No, we can see the building from our house.
Okay.
So it's your intent to knock down the vast majority of the building and build a completely new structure?
Reconstruct two-thirds of the space that's there, the footprint that's there, and preserving this has all been approved. So we've gone through the diligence of the Heritage Preservation Board, got a unanimous vote from them. And the two hangups that we've had were with our original contractor that I referenced earlier. And the second hangup was our structural engineer, who overstated his understanding of structural insulated panels, which is the building technique that will be, or the building material that we're pursuing for energy efficiency reasons. So we want to turn this into like a green home. And so that caused about a 6-month delay. We hired his firm in May of 2013, and they promised us an August delivery, and here we are, and it was very early February when we got this package.
Very early this month?
That's correct, yes.
The builder could not build according to the first structural engineer's plans because of the materials that we are requesting the builder to do. And so the builder said, I can't work with the structural engineering plans. So it went back to him, and we just got the revised one just recently now.
Make no mistake about it, I'm not opposed to extending your date. I just want to make sure that all of these things that we have on this list, these were all approved at one time. And now what you're asking us to do is approve the demolition of all of these things?
The plan has always been to pursue this structural, this rebuilding, this strategic demolition and rebuilding. That's always been the plan. The plan has never been to address all the violations. Once a certificate of approval is granted by the city, we will be in compliance because it's an active construction site.
So what you're saying is things like general plumbing, interior
That will all be
surfaces,
new.
openable windows, roof and drainage will all be done after demolition. Is that correct?
It will be a new structure, essentially.
Let me just jump in. They either need to fix those things or demolish the building.
Right,
They're going to demolish the building.
right.
Once they demolish the building and they get the certificate that they're talking about, they'll be in compliance. So we don't really care how they come into compliance as
Right.
the board. He's telling you how he believes he's going to bring it into compliance with those plans and with the approval from the building department.
Okay.
So, and ultimately, the city makes the determination whether it's in compliance or not. That's their plan of action.
How long do you think it'll take you? Now that you have the plans?
See, okay.
These plans, we intend to sign a contract with our lead contractor this coming week. He's been working at risk
Okay.
for the entire year and a half. We've been almost 2 years we've been engaged with the gentleman.
Mhm.
He's been fantastic. Once that's in place and he gets paid, he'll submit these it's within a week or two. These will be submitted
Okay.
as early as next week. But
So,
I would count on within the next two
so
weeks.
as our attorney has so stipulated, all of this stuff will be blown up, right?
With the exception of the facade and the bell tower.
Yeah, right.
The
I
historic-
understand
right.
that. I
That's
understand
correct.
that.
That's correct.
But all of this other stuff, so therefore, as far as we're concerned, it'll come into compliance.
That's correct.
So, okay, are you done?
Go ahead.
Okay, and maybe this will help, because I remember this, but I think a lot of you are new since
Well, I think you
this
and I were the
happened.
only
But
ones on the board.
wasn't your original plan to just redo this, and then you found out evidently that it wasn't doable?
There were structural integrity issues with the building
Because-
from the time my father acquired it in 1973.
Can I add to that? We bought the building in 1973, and it was vacant for 5 years. The First Baptist moved out, and I didn't realize how much damage was already done. to
Yeah,
the building.
right.
And I have a letter that I was late in submitting to the code enforcement people that explains an awful lot, if you'd like to look at that.
Oh, I don't think that's necessary.
No, I think
that
you've explained it
clarifies
well here.
That these were violations for you to fix, but you can't fix them, you want to tear it down, and that erases the violation. So I just don't understand, why we wouldn't want to, go along with
Yes.
this.
I know it.
Has anybody determined how much extra time they need?
But realistically, you have the print, you're gonna give them to the contractor, he's gonna submit them maybe within a week or two. How long is it gonna take the city, and how long is it going to you actually going in and demolishing and taking care of those violations? Are we talking a month, 6 months?
The violations are no longer on the table, is my understanding, once the city approves the plan.
Sir, let me ask you a question. You haven't answered the question I asked previous. How long of an extension do you need? You say you want us to give you an extension. How long of an extension? I just need give me a date. What are we talking about,
I'm
time-wise?
trying to understand when is a active construction site in compliance with these violations?
When they're gone.
Do you have an estimate, sir? Is it 30 days, 60 days? Is it open-ended? Would you answer my question, please?
You may need to get that answer from the building official, how long it would take to process the permit application once it's actually filed. Maybe he could help you.
Okay, somebody could help me, maybe.
Okay.
Can I answer that, Tom? The current policy is 25 days.
So we're only talking about a 25-day extension? Is that?
In addition to the week that it's going to take for their contractor to submit them or whatever. That's, once you get them, you have to have a turnaround time of 25 days under your own internal
Maximum,
policy.
yes, sir, maximum.
So if we might be talking 60 days should cover everything?
Yes.
Well, I don't know, how long does it take them to get somebody in there to tear all this down? I'm
They're gonna
not
blow it
sure
up.
30 days is.
Well,
No, it's not to tear it down. It's, if that's what the building official is saying, that it's in compliance when they get their certificate. In other words, it becomes a construction site. Is that the position the city is going to take?
Once the permit is issued, yes, sir.
Okay, there you go.
Yeah,
Okay, so it doesn't
60
have to be
60
torn down
days.
to come into compliance.
60 days to give them time.
Would 60 days sound reasonable?
Well,
yes, I think that's more than fair.
Okay.
Yeah, if we said 30 and it took 33, you'd be back here again. So let's say 60.
I don't think so.
I don't understand exactly,
Well,
what, we have to go through demolition, we have to go through, that doesn't, that's all after.
Let's take a step back.
That's all after.
Let's take a step
Okay,
back.
then it's okay.
Because there's actually structural shoring that has to happen first to protect the structures we'll be preserving. And so that's why I hesitate, sir, with your question, is that that's a separate stage in the process.
You indicated you testified that once you get this approval from the city, you'll be in compliance.
That's correct.
This is a city official. He indicated that what it would take 30 days for that, right?
25, yes, sir.
25,
Yes, sir.
okay. Can somebody just answer me, when would the city consider this to be in compliance?
At that point of permit issuance, this case will be in compliance.
Okay. So when we
60 days.
indicated 60 days, we were willing at least
60 days.
to propose a 60-day extension. Would you consider it from the city's point of view that would give them ample time to do whatever they had to do to meet these violations?
Not knowing the extent of the drawings or where they are with their contractor, I think it would be a question for them, sir. For
Okay,
us to
but-
process the permit.
I'm not getting any answers. I don't think, personally, I wouldn't have a problem with 60 days if that meets people's need.
I think
But-
you're on the right track, and all the answers are there. And I think I'm ready to request a motion from the board if all the questions have been asked, but I would like Mr. Trask to repeat what the actual request is.
I would think that the appropriate motion would be, I move to set aside the acceptance of the affidavit of noncompliance and extend the compliance date to, and then set that date. Today is February 13th. If you're saying 60 days, it may be April 13th
April
then,
15th.
April 15th, that's a wonderful date.
tax
Yeah,
day.
tax day.
Would someone like to make a motion?
I will.
Yes, I'd like to make a motion, what he said. I would like to extend the date to April 15th, 2014 for the individuals in question to obtain proper documentation and certification from the city of Tarpon Springs, which at that point will put it in compliance with code enforcement.
I don't like the way that's worded, because you said
We need that too.
something about,
You need to set aside the current one.
Yes,
Setting aside the current one and extending
affidavit
it
of
to
noncompliance.
April 15th, 2014.
to come into compliance. That would make sense to me.
Yes, to come into compliance.
I'll second that motion. Just to let you know I wasn't
We
there.
have a motion, we have a second. Is there any discussion? Bobby, may we have a roll call, please?
I'm sorry. Would there be a money attached to this if failure to go past?
It's the same fine as it was in the
Thank you.
prior order.
It's
All
just
we're doing
time.
is we're extending the compliance date. So if the last
Thank you.
compliance date was, let's say, December 15th, now it's April 15th. If they don't come into compliance by April 15th, then it would be that fine that was
Very good.
issued in that prior order.
Okay,
Yeah.
original fine. Okay,
Okay.
thank you. Mr. Plunkett,
Yes,
Mr. Slavinsky,
Yes.
Mr. DeMoss,
Yes.
Mrs. Archer,
Yes.
Mr. Kramer,
yes.
Ms. Vacacy,
Yes.
Mr. Vesey,
Yes.
motion carries.
Good deal.
Good
So
luck,
what-
gentlemen.
What will happen, Mr. Beckel, is that within the next 10 days, an order will be prepared. I'll help Bobby with that order because this is a little bit different. They don't normally do stuff like this. And the order will be sent to you. It will reflect that the prior order has been set aside to the extent of the compliance, and you'll have until April 15th. And if you fail to bring the property into compliance by April 15th by getting the permit that the building department will issue, then that fine will start. So,
Thank you.
When, just off the record, when do you anticipate this beautiful thing being completed?
The construction method for SIFs is quite efficient. It's probably going to be the structural and demolition, shoring and the demolition is going to be the lengthiest part. Once that's done, I believe it should be a 6-month work site as
Yeah,
far as,
good.
it will look like a finished building, but
Look
the-
forward to it.
the groundwork is the lengthiest lead item.
Are you planning to make that your home?
Yes.
Oh, wow.
oh, it'll be
I'd
nice,
love
it'll
to
really
see
be
that
nice. I'm
when you
looking
get
forward to
done.
it.
It's going to be beautiful.
We have no minutes to approve.
Reading material here.
Any
Yeah.
public comments?
since there's no public?
No public comments? Any board or staff comments? Adjourned
Happy
at
Valentine's Day.
3:10.
Oh, you were way off.
Staff comments?
I just,
No,
Dad, you can't.
no, you have to ask, you have to show it to, that's fine, just show it, if they want to see it, you have to go through Ms. Sanders first, that's all. Okay. Just want to make everything good.
Just go ahead and hand
is this the one you should be
Yeah,
getting?
right.
Yeah, it's fine.
No, he's lobbying, that's okay, that's permitted.
Okay, thank you, sir.
Very excited about it.
Then you run for office.
Lobbying's permitted.
And you run for office, right?
Yeah, here's what the church, what they're doing, so you can, he's bringing them around.
Thank you. I'll read it carefully. I'll read it carefully.
No.
Thank you.
Cindy
Glad we could
Sanner.
help. Good luck.
Thank you.
Thank you.
I don't know if too many people are aware of this, but there are coyotes in Tarpon Springs, and more recently, the other day, one of my neighbors saw a coyote across the street from my house.
Can I have one, please? I just put in here.
If people have pets that they let out, like cats, dogs, whatever, several cats have gone missing from my neighborhood that belonged to residents. Please do not let your pets run at large unless you want to lose them. And it's also against code to let your pets out without a leash or within voice control. And I don't think too many cats are going to be within voice control. So please keep your pets indoors. There are coyotes. If you do see one, report it to Pinellas County Animal Services. They're keeping track of where the coyotes are. And I live on Charlotte Avenue, so anybody that lives near Howard Park. I know some have been spotted in Point Alexis and also on Carlton, Curlew Place, just south of, east of Florida Avenue.
Right.
We have one in our neighborhood.
Did you? Okay.
Where do we get a hunting permit?
No, don't do that. So anyway, keep your pets inside, please, because it is a code violation, and you want to keep them safe. Thank you.
Thank you, Cindy. Adjourned. 3:12.